My name is Tina Ro-Connolly. I'm the Senior Counsel with the Law Offices of Amy Oppenheimer. We are an office that specializes in workplace investigations and trainings.
And I am Monica Cooper, Assistant County Counsel for Contra Costa County.
And our presentation was about the impact of the Me Too movement on employment laws, investigations, and litigation. And before we sort of launch into the impacts, what we'd like to do is just give you a brief history lesson of how we got here. Really, it started back in 1964 with the Civil Rights Act, and which prohibited discrimination against people based on their sex, among other protected categories. And even though that was passed back in 1964, it wasn't until the mid-'80s, so 2 decades later, that we really saw this issue of sexual harassment also being considered as protected under Title VII. And that was in the seminal Supreme Court case of Meritor Savings Bank versus Vincent. And ever since that case was decided, we see a lot of momentum in terms of other case law, trying to interpret and understand how and preventing sexual harassment in the workplace and other forms of harassment as well. In the 90s, you see a whole slew of case law, the Farragher and Ellerth decisions, the Cotran decisions. Also in the 90s, the Equal Employment Opportunity Commission, the EEOC, they also released their guidelines on vicarious liability for harassment. And you also see in California mandatory sexual harassment prevention training. How-to books are being published, and including most recently in 2017, the Department of Fair Employment and Housing, the DFEH, they also released their guidelines regarding harassment in the workplace. So you see all this momentum, and you see all this education and awareness around sexual harassment and harassment in general in the workplace. So you would think that harassment in the workplace has been eliminated and we can move on to other more pressing issues that need to be addressed. However, obviously, 2017 happened. The floodgates opened with allegations against Harvey Weinstein, Donald Trump, Roger Ailes, Bill Cosby, et cetera, et cetera, et cetera. And out of the ashes, the Me Too movement is born. So how has that impacted our practice as employment attorneys? Well, I can say that as a workplace investigator, I think the biggest impact we've seen is an increased level of scrutiny in terms of our credentials, our ability to be impartial, our biases, questions about who can see our report, who can remain anonymous in our investigations. All these questions are starting to come out, and really what is motivating that is this increased desire for transparency, which is certainly understandable and which is something that employers also want to be able to address. However, there's also a push and pull with that, and the tension that's created between increased transparency versus the chilling effect of those who are involved and part of these investigations, and the fear that they have that their names are going to be attached to the report. People are going to know what they said about other people. So that is definitely an increased consideration for employers in this post-Me Too world.
And I would just say that is very important because for our county, for our companies, if people find out what other people have said, the destruction of the environment can be huge, and people have to be free to express themselves and tell the truth, but you don't want that to stifle the working environment. You want people to still be able to work together, get their information out, but have that, as much as it can be, protected.
Yes, definitely. So we've seen a lot of employers implementing new policies, new procedures, creating investigative units to address these types of complaints that have come in. Because I think what we've also seen as an impact of the Me Too movement is it's not just sexual harassment complaints that you see, but all types of complaints. People feel very empowered and emboldened to speak out about any type of issue that they see in the workplace. So now we have questions about who's going to investigate all of these. It can be very timely, it can be very costly, and it can be very, very disruptive to the workplace. So there has to be procedures and policies that are implemented regarding, okay, these are the types of investigations that we're going to these are the types of complaints we're going to investigate. Here are the types of investigations that we're going to have HR investigate, and here is how we're going to determine who investigates what, and also just the resources and the thought process available to break the rules if and when, on a case-by-case basis, when that's required. I think also another area that the Me Too movement has impacted, which has been significant, is the change in our laws. In California alone, we've seen a lot of proposed legislation, some of which has been passed, some of which hasn't been passed. But the biggest is probably SB 1300, which increases the training requirements. It also clarifies the legislature's intent that a single act can meet the threshold for severe and pervasive in the workplace. And also, we've just learned that the governor signed into law an increased statute of limitations.
That'll be very problematic for us, and I think actually both sides. I could be biased.
Well, I think the biggest problem that comes along with an increased statute of limitations is people's ability to remember,
Right.
and people's ability to recall the events 2-3 years or more after they've occurred.
And I'm sure you run into that a lot because in
Yes.
your investigations, you're talking to people about things that have happened, sometimes years before, and memories. We wish they were better, but they aren't. It's a reality.
And so on top of the Me Too movement impacting policies, how investigations are handled, and the law, Me Too has certainly impacted litigation practice as well.
Right, right. Well, and we have seen, as Tina talked about, we have seen a huge increase in just general employment actions, not necessarily just sexual harassment claims, but employment actions in general. In fact, in 2017, we had 1 employment case. 2018, we had 8. And in 2019, in 2018 we had 9, and already in 2019 we have 8. So we're on par for, really completely going over what we have in previous years. So that has seen a huge increase. But one of the things that I think is most important is you have to jump on these things early. You get a complaint, you have to address it right up front. You decide whether it's going to be an inside or an outside investigator. And one of the things is you have to train your internal investigators. Cost is an issue. We still, I think, are now, after Me Too, going outside to more investigators, more outside investigators. Part of it is with attorney investigators, you have that attorney-client and work product privileges, as we got in City of Petaluma case, which we're fortunate for. And so we decide, how are we going to do that? Are we going to use the investigation, or are we going to keep it confidential, attorney-client work product? It's also very important to make sure that not only are people getting their sexual harassment training, but that people understand they're trained how to be supervisors. Some of this stuff can really be addressed with frontline supervisors. And so if they're trained how to manage people, and I'm sure that you see this a lot, that a lot of these complaints come out of interpersonal conflict. And if we can address that on the low level, we might be able to avoid some of these. There also, we're getting a lot of old complaints. After Me Too, we have things that have come up from many years past, and we decide how we're going to handle those on a case-by-case basis. But the one thing that I always stress with internal investigations, which Tina knows because she's an expert, is document. No matter the level of your investigation, document. That's the most important thing that we can do in our internal investigations, because obviously you do document your external investigations.
Right. And that's certainly what you need for purposes of litigation, right? Is
Right.
documentation. Yeah.
Right. With these new laws, we also have the motion for summary judgment is not necessarily viable, so that increases costs. Could increase settlement costs. There are a lot of, with the new laws, a lot of considerations for litigation practices.
Right, and Monica was referring to the changes in the law under SB 1300, where really they discourage summary judgment motions and the impact that has to her litigation practice.
Right.
And you know, and I'll end this by saying, all of this is a work in progress. Employers are still grappling in so many ways about how to handle these issues and address investigations and their processes through their policies. But there's also this ongoing issue of public misconception and about the ongoing education that's required of the public. For example, the burden of proof in these investigations, so in this notion that that the accused is innocent until proven guilty, which isn't the standard of proof in workplace investigations. And also this notion that the allegations have to be corroborated in order to be credible. And that's also incorrect. We as workplace investigators, we're constantly being asked to make credibility determinations in he said, she said, she said, he said, she said situations with no corroborating evidence. So corroboration is not a factor that we consider in context of credibility. So lots of work to do. It's an ongoing process, and we're thrilled to at least be able to share what we've learned thus far with all of you.
Thank you.